In no particular order other than the order in which they've seated themselves on the stage, I'll introduce you to the folks on this panel. To my left is Denise Weeres, who's the Director of Corporate Finance. To her left is Ryan Clements, who is the Director of the newly minted Advanced Research and Knowledge Management Division at the ASC. To his left is Cynthia Campbell, the Director of Enforcement. To her left is Katrina Prokopy, who is the General Counsel. To her left is Brian Banderk, our Chief Accountant. And at the end of the line, but certainly not the end of the importance line, is Lynn Tsutsumi, who's our Director of Market Regulation. So during this panel discussion, we hope to offer you insight into which regulatory priorities the ASC has identified as those upon which we need to focus our attention and resources. Going back to our theme, our emphasis is on advancing and maintaining a capital market that is defined by its ability to allow for growth and innovation, and the rules of which are always guided by the development and implementation of intelligent regulation. Each of our panel members leads a division within the ASC, and they collectively significantly contribute to the execution of our mission to foster a fair and efficient capital market in Alberta and to protect investors. Our panelists will share with you how ASC staff are addressing the key issues that our capital markets are currently facing. So I'm going to turn it over to each of you. I know you've prepared a short and sharp introduction to really bring the focus of your division's activities to the audience today. Who'd like to start? Denise, would you like to go first, since you've decided to seat yourself to my left?
All right. I think there was some other order that we were supposed to go in, but I will start. So you just heard, for the last hour, you heard about one of our top priorities in the Corporate Finance Division, and that is the climate-related disclosure. So I'm not going to speak further about that right now. And this morning, with our Chief Executive, Stan Magidson, on that panel, they spoke about the diversity disclosure and our efforts there within the CSA to harmonize that. That's another priority. But since we've spoken about that, I will talk about a few others. One of the areas of focus for us, it was touched on a bit with the opportunities for Alberta panel this morning that Craig Burns was moderating. Craig heads up our energy group in corporate finance, and that's a team of engineers, geologists, and energy analysts. And they have traditionally been our subject matter experts for oil and gas disclosure and sort of understanding the oil and gas industry, so looking at reserves and resources disclosure. But and I think Craig mentioned this earlier this morning, they've been broadening their scope to all things energy, so oil and gas plus. And that's, you know, like midstream pipelines, energy services companies, but also sort of the emerging sector, so hydrogen and helium production, carbon capture and storage, of course, as well as the renewables, geothermal, solar, and wind. And really, you know, the reason for that is to assist us with sort of compliance, so we can assess the disclosure, you know, if it's realistic, if it's greenwashing, but also to assist us with policy making. And I think, you know, one of the goals is also to be a resource as issuers move into those spaces and understanding sort of what the disclosure expectations might be. I think Craig and his team are finding that a lot of the learnings that we have, you know, from our history of like monitoring the disclosure of energy projects, oil and gas projects, it can be leveraged and it's useful and informative for other energy production. Another priority for us in corporate finance is continuing to advance the remaining regulatory burden reduction projects. So a number of them have already been finalized at the market distribution, streamlining business acquisition reporting, the listed issuer financing exemption. Those are a few of them, but there's a few projects still in the works. And I think if implemented, they could both reduce regulatory burden for issuers and make it easier for investors to understand and access disclosure. So those include the expansion and codification of the well-known seasoned issuer financing exemption that was implemented by way of a blanket order on a temporary basis. We're looking at codifying that and expanding it, which should provide faster access to market for those larger seasoned issuers and more deal certainty. So that's out for comment right now. One of the projects that Alberta Securities Commission staff is co-leading was the streamlining of the continuous disclosure by reporting issuers. And we're really done on that project. The work has been done, contemplates an annual document that's the combination of your AIF, MD&A, and financial statements, similar to sort of the US disclosure system, and a similar combined interim document. The work is done, but really that's been paused as we sort of revisit our approach on delivery of those documents. So whether it's electronic delivery or access to those documents. So we're working through that. And that's really true for both corporate issuers and investment fund issuers. As well, I should mention on the investment fund side, looking at reducing burden there, both streamlining things like the prospectus offering system, extending the lapse date, and streamlining and modernizing continuous disclosure. And then just locally, just to wrap up, some of the things we're looking at in order to assist with regulatory burden is more webinars, more seminars. Basically, every time we roll out a new rule, to be able to offer that to help issuers with sort of capacity building, and looking at building out some more website content on securities law requirements, something that hopefully is more accessible than sitting down with a national instrument and a cup of coffee and trying to wade your way through that. One area that our team's just been working on recently is on investment funds. So to sort of assist those that might be interested in that space in Alberta and to be a resource for market participants.
That's great.
Hello, everyone. My name is Ryan Clements. I'm the Director of Advanced Research and Knowledge Management. My division is a new division. It is designed to be collaborative across the operational divisions and alongside IT and communications and HR. We work to facilitate the ASC's mission through effectively 4 objectives. We have a data and analytics function, and part of that is we have a dedicated and very talented group of data analysts and scientists who perform a supportive and accessible role to operational divisions. We lead data projects that support evidence-based policy decisions. We're involved in improving data governance processes, because in order to do good data analytics, we need good data. We are involved in internal projects around data and analytics, including the Alberta Capital Markets report. We also serve on a variety of CSA working groups and projects in relation to data governance, market analytics, and we're used in a variety of functions, including systemic risk. Our second objective is to facilitate tailored educational initiatives within the ASC. So foundational educational offerings designed to help staff understand why we exist as a regulator and who we regulate and what primary tools we use. We're involved cross-divisionally in tailored educational initiatives to help facilitate specific processes in terms of what's involved for staff in a regulatory environment. We're also helping to facilitate educational initiatives around emerging areas, particularly emerging technologies and emerging risks, which leads into kind of the third pillar, if you will, of our division, which is timely research around emerging risks that will impact capital markets. And so we're heavily involved. This has been a theme that's come up several times on these panels, and I'm going to lead a panel next actually on this, is some of the concerns around emerging technologies such as artificial intelligence in capital markets and the diverse crypto asset ecosystem. So we're engaged in a variety of research projects and internal working groups, and providing an augmenting function across divisions around new technologies, and also assisting in various CSA groups around emerging technologies that have impact in our capital markets. And finally, we lead the ASC's non-operational efforts in technology testing. So not only are we looking at technology from the perspective of how it impacts the registrants that we regulate and also marketplace participants, but we're also looking at how technology can provide a regulatory function or a surveillance function. So we engage in various testing initiatives, and we're also interface with the technology community, and we also facilitate engagement through the CSA, through similar groups across the CSA jurisdictions, through a financial innovation hub that we have.
Thanks, Ray. Hey, good afternoon. I'm Cynthia Campbell, the Director of Enforcement at the ASC, and for those of you who are wondering, when are we going to talk about enforcement today? We're finally at that point in the program. A few things I want to touch on just at a high level about enforcement and what's top of mind for us at this point in time, what's evolving. The first is the fact that we're seeing increasingly the internationalization of securities misconduct. This isn't new, the internationalization aspect. It's been around 40, 50 years, but it's intensified in the last few years in very significant and dramatic ways. So it doesn't matter now whether we're looking at cases that may involve insider trading or market manipulation, other forms of market abuse, fraud, legal distributions. It doesn't matter. We end up with participants and actors, victims, investors, issuers, bank accounts, trading accounts. We end up with this dispersion around the world of information and evidence that we need to be able to assess in order to properly determine what's happened. So as you might appreciate, that adds significant complexity to the work that's being done. It also means that we increasingly need to find ways to cooperate internationally in a very swift fashion so that we can jump on new trends and take action with respect to them. We're also very much looking at enforcement. We'll talk more about technology this afternoon, but the fact that technological developments are exponentially increasing the risk of harm to investors and other market participants. There are a lot of tremendously fabulous uses for technological developments and advancements, and other panels will discuss that. But from an enforcement perspective, we see where technology and AI in particular, artificial intelligence, poses great risk of harm. And I'll touch more on that in a few minutes, but for now, suffice to say that every person is potentially can be a victim, and I'll get into that in a few moments. I think it's worth noting that in Canada during the past 2 years now, investment fraud is one of the fastest growing crimes in this country. And Canada is unfortunately one of the leaders in the world for the amount of victimization through investment fraud. So it's obviously something very important to us and with our various partners in law enforcement that we work with. Third point I'll touch on briefly, and it flows in large part from the first couple things I've mentioned, is that we're really focusing on how do we be strategic in assessing what types of enforcement action we take on different matters. So traditional enforcement has focused a lot on investigations and litigation or prosecution. As misconduct expands, as it increases at an accelerated pace, we need to be more agile and move swiftly. We need to be able to participate and amplify our capabilities in enforcement to prevent, to detect, to disrupt, and to educate the public on what we're seeing in real time in terms of harms. So I'll leave it there.
Hi everyone, I'm Katrina Prokopy. I'm the General Counsel at the ASC. The Office of the General Counsel is the in-house legal policy, strategy, and risk management resource for the ASC. So largely what's top of mind for my colleagues in the operational divisions is top of mind for me. I have the exciting job of getting to get involved in a lot of the issues that you've heard about today and are continuing to hear about. My team provides support to the operational divisions, but focusing on the policy initiatives and rulemaking amendments on things like statutory authority, jurisdictional questions, statutory interpretation, admin law issues, and legislative matters. The Office of the General Counsel is also largely involved in all of the corporate governance-related initiatives that are underway, since we provide support to our internal governance function. So a number of these governance policy projects you've heard about today, the diversity disclosure, this relates obviously to the amendments to corporate governance disclosure requirements beyond representation of women, aimed at enhancing issuer disclosure at the board and executive level in diversity characteristics beyond the representation of women, as I just said. The second corporate governance initiative that we've been involved in is the CSA's Indigenous Task Force. I don't think we've spoken about this today yet, but the CSA has been doing a lot of work thinking about how we can, as securities regulators, appropriately engage with Indigenous communities in the course of our policy development work. We've been getting specialized external advice on this and are building a lot of relationships, working on identifying how to undertake this engagement in the course of the work that we do. And lastly, from a governance perspective, the climate-related disclosure, which we've talked a lot about today, particularly in the last panel. The Office of the General Counsel has been providing input and support to our corporate finance colleagues as we work on identifying the appropriate way to incorporate the climate-related disclosure ISSB standards into our issuer disclosure requirements. One thing that was touched on today that we're spending a lot of time looking at right now is the safe harbors, looking to achieve the balance and proportionality, but through carefully crafted legislative safe harbors or defenses from liability for our primary and secondary market statutory liability. We think these are important in order to address some of the challenges for issuers at this stage of things with some of the aspects of the climate disclosure required under the ISSB standards. As we spoke about earlier, some of the potential uncertainty or unreliability of disclosure in relation to Scope 3 emissions and scenario analysis. The rationale for these safe harbors that we're thinking through would be that some of this uncertainty could lead to significant issuer liability exposure for issuers and for the directors and officers. If their climate-related disclosure was inadvertently, despite having been made in good faith, proved to be inaccurate and inadvertently became or could be argued to be a misrepresentation under securities laws. So we've been looking at our existing civil liability regime and our defenses to liability under our current framework and considering what may need to be adapted or added or tweaked to specifically address the climate-related disclosure. And then I think the last sort of top-of-mind project that we're working on my team is the OBC Binding Authority project, which was spoken about earlier this morning. I think Grant spoke about it. This has been underway for some time. The current framework does not have OBC with the authority to make binding decisions, and the data and consultation and industry feedback we're hearing is that this is out of step with other international financial ombudsman organizations, and so from a legislative and statutory authority perspective, we've been doing a lot of work looking at the right way to implement binding authority decision-making for OBC. Again, from a legislative and rulemaking perspective, we're nearing the final stages of landing on that framework and expect that the market will see something shortly coming out for comment in that regard. And that's it for me.
Hi everyone, Brian Banderk. I'm the chief accountant. You know, it really is a very dynamic period right now when you look at accounting, auditing, financial reporting, and even the CPA profession itself. And you know, some of my lawyer friends up here kind of poke fun at me when I use dynamic and exciting, but I'm sticking with it. So, you know, when I really think of what the Office of the Chief Accountant focuses on, and you look at those 4 items, traditionally we would be more weighted towards that accounting side of things, and I would say we've really seen a shift to those other 3 that I mentioned. So, not that accounting isn't important, but and a key part of what we do, but we are focusing on some of those other areas. So, really quickly on the ESG side of things, we're really there as a support role for our dedicated ESG team that's led by Jonathan Taylor, who you had a chance to hear from earlier. You know, what we look at is really that, you know, connectivity between the ESG disclosure and the financial statements. What's that going to look like? You know, we can lend our expertise and knowledge and experience on financial reporting and really even our experience with the standard setting process itself. You know, we've kind of gone through a lot of what's being considered on the ESG side when you think about the way that we adopted IFRS, having an international body and standard setter and a Canadian standard setter, etc. The second item I kind of want to mention, and it's kind of carries on that same theme, is just the structure of standard setting in Canada and of the profession itself. You know, consistent with efforts around the world, or a lot of the other jurisdictions around the world, the Canadian accounting and auditing standard setters are really taking a deep dive into their structure, looking at, you know, how to structure themselves in a way that's both reaches you know, an actual and perceived level of independence, as well as long-term sustainability from a funding perspective and things such as that. So, and now you have obviously ESG as part of that as well. And the CSA being comfortable with the structure of accounting and auditing standard setting in Canada, you might imagine is quite important to us, because the way that we bring those rules into our securities regulations is we incorporate it by reference. So, you know, being comfortable with the oversight structure as well as the overall dynamic and who's involved is really quite important to us. So we have been involved in the process to date. It's quite a ways along, and will continue to be as the recommendations that have been put forward are kind of into the implementation stage itself. Now, you don't have to search too hard into the headlines to realize that the CPA profession is in a period of reflection. You know, really looking at the dynamics between the provincial CPA bodies and CPA Canada with 2 specific provinces in particular. You know, this is a situation that we're monitoring, and, you know, we're having the discussions with the key players, the key individuals. You know, having a healthy ecosystem for CPAs in our country is really important to the functioning of the capital markets. So the third one I want to talk about is assurance standards. You know, and specifically what we're looking at there is, you know, there's some big things happening or being considered, and they're in various stages of development when you look at areas such as, you know, assurance procedures on going concern, on fraud, of course, ESG, as was mentioned earlier, there's a exposure draft out. And then also just thinking of audit quality in general. You know, unfortunately, there's been some high-profile international business failures, and it's really put the spotlight on the role of the auditor. What else could they have done in those situations? So we have been and we will continue to engage with the standard setters in specific areas like audit procedures on going concern and fraud, like I mentioned. And then with respect to audit quality more broadly, you know, more than ever, we will need to continue to communicate with, on an ongoing basis with the Canadian Public Accountability Board and their audit inspection findings. And maybe I'll leave it at that, and we can hear from Lynn.
Okay, well, it's been a long time since Samir introduced us, so I'm Lynn Tsutsumi, Director of Market Regulation, just to remind you. And market regulation regulates trading, dealing, and advising in securities and derivatives, and now crypto assets. And I just want to mention, to Katrina's point, Market Reg and the GC's office work very closely on this OBC file. And, you know, we know that it's the outcome of that is important to industry, and we are, you know, working towards a fair solution. So, you know, one of the most important things market regulation does is we register and oversee the conduct, compliance of certain categories of dealers as well as portfolio managers. And part of that compliance oversight function is doing a normal examination schedule where we go in and we test compliance. But in addition to the normal exam cycle, we also pick special topics that we want to take a closer look at through more narrow examination focus. We call them sweeps, and I want to talk about a couple of those. Recently, we went out to see our scholarship plan dealers, and we've completed those examinations. We saw a spectrum of compliance, and we're working on resolving some remaining issues with those on one side of the spectrum, and you'll hear more from us soon on that topic. Brenda brought up the client-focused reforms this morning. She mentioned that the CSA had gone out to do a compliance sweep, and the topic was conflicts of interest. And so we are about to embark on another sweep along with our regulatory partners, CIRO, to look at know your client, know your product, and suitability. And the last area of special interest is how some of the bank-owned dealers are deciding what products they'll make available to their clients, and whether those decisions fit with our intended outcomes for the client-focused reforms. And the next topics have been picked based on the level of intensity of feedback received from our community, but they've also been touched on by the CEs this morning. Andrew talked about directed commissions, the issue of directed commissions, and this typically involves an individual registrant having their income directed to a holding company for tax planning purposes. And CIRO is undertaking a process for their membership. However, the registrant community that we directly oversee is also extremely interested in getting to a resolution on this topic. So stay tuned, we know it's important, and we want to find a solution that appropriately addresses risk to dealers and investors. Third topic I was going to talk about today, short selling. Grant talked about short selling, so all I'll say is that we have directly heard from market stakeholders that have raised concerns around perceived inappropriate short selling. And the impact of that is to lower stock price and make it harder for companies to raise money. So this is of particular concern among small and micro-cap companies. So all I'll say is we're going to be publishing something soon, and the future work will include public consultation, which CIRO will be leading. I think I've got some time because the CEOs saved me some time here, so I'm just going to say that another thing that's keeping us busy is novel registration files. And it's not just crypto trading platforms, although they do form part of those novel files, but they are becoming more common. And I will say that there is a tech innovation thread to it. And they make us carefully consider the regulatory balance in applying existing rules to new products and processes. It's been testing us. And I will say I'm lucky to work at the ASC because all the divisions represented by their directors here today work hand in hand to identify the facts. And that is sometimes, really the important part of it because sometimes we don't recognize what we're looking at. So identify the facts and then we can find a path forward. And we also work with our CSA colleagues to attempt consistent treatment across the country. So it's a true team effort. That is all.
That's quite enough, don't worry. Thanks to all of you, that was great. I hope everyone got a really nice flavor for what each of the divisions and the directors are responsible for. I'd like to dive into a few questions, and while I'm doing that, please do take the opportunity to get on the Slido app and submit any questions that you have. If you include your name and your email address, if we can't get to them, or because they're very technical in nature, they're best suited to be responded to outside this event, we'll certainly do so, but do please submit your questions. So I'd like to start off by exploring what our analysis of the market has yielded in terms of observations, and in particular, like to talk about what the challenges and opportunities are, what stakeholders are telling us, and how we're responding. So I'll point my first question to you, Ryan, in particular on the capital market data. What does it suggest to us, the data that you're seeing and analyzing?
Thanks, Samir. So I'm going to give 5 observations. Now, we just published in the summer the capital market report, so I'd encourage you to take a look at that if you want to take this a little bit deeper. Some of these observations may not come as a surprise, others might surprise you. So, number 1, compared to 2021, the oil and gas industry percentage was larger in 2022 at 48% compared to 40% in 2021. And the utilities and pipeline industry was smaller at 31% compared to 35% in 2021. Now, interestingly, observation 2, debt issuance makes up more than half of prospectus and prospectus-exempt financings. The observation number 3 is that reporting issuer use of the prospectus-exempt market is significant. A lot of times people don't realize reporting issuers routinely utilize prospectus exemptions. Reporting issuers make up an average of 27% of prospectus-exempt market issuers over the past 10 years. 4th observation, Alberta-based investment fund distributions make up a fairly large portion, 26% in 2022, of the prospectus-exempt market, and in 2022 were also the largest industry by distribution amount. And finally, despite a decreasing number of reporting issuers over the last 10 years, the average size of Alberta-based public issuers has more than doubled. Total market cap of Alberta issuers has been increasing, up 20% over the last 10 years.
Okay, that's great, and that's exactly the kind of data that we've been hearing people talk about, saying that you need those numbers, that analysis, in order to inform the policy-making function. So we're glad your group is on top of that, Ryan. Brian, I've got a question for you. Access for reporting issuers to accounting professionals. What are you hearing about the market, and are there any challenges in that regard?
Yeah, so thanks, Samir. So yeah, there's no question that we are hearing from stakeholders that there is a challenge in finding access to qualified accounting professionals, and they really are a key ingredient to the capital markets. You know, if you look at within reporting issuers or registrants, either preparing the financial information or reviewing it, for the audit firms, making sure they have properly trained public accountants who can conduct the audits, and for sure in governance roles as well, to serve on boards and as part of audit committees. So, not unlike a lot of professions out there, you have a situation where there's aging demographics, you have increased demand for CPAs and the skills that they can bring, and unfortunately, I would have to say enrollment numbers just aren't necessarily keeping up across Canada. The CPA profession is looking at the way that it attracts talent and its process of certification. So basically, how do you modernize to appeal to the next generation of CPAs? Now, this isn't, as you might expect, this isn't an area that we have any direct decision making in, but we also have a great relationship with the CPA profession. So we're definitely here and providing our observations on what's going on, and we're always happy to help. Now, obviously, there is a balance to be reached here. You know, what we don't necessarily want or isn't going to help is to have a huge number of new CPAs unless they're, you know, there's a group of those that are certainly trained up and well qualified in the area of public accounting. Another kind of theme along this is the access to auditors. And, you know, we've certainly heard it's not like a few years ago where if it was time to kind of look for a new auditor, you would have 5 of them willing to take on your audit at a very reasonable price. You know, we've heard that some issuers are reaching out to 5 different auditors, and maybe only one of them is responding that they're willing to take on the audit, but it's at an increased cost. So there's no question that audit firms are being more selective, and, you know, I think that's somewhat based on their own resourcing, as well as in some case just looking at the risk profile. What type of clients are they wanting to take on at this stage? And we recognize, you know, this can be very frustrating to impacted reporting issuers as they need audited financial statements. Now, often the audit firms will note that the high expectations around conducting a public entity audit is challenging for them, which you know does include being subject to inspection by the Canadian Public Accountability Board or CPAB. So, you know, we do work collaboratively with CPAB, you know, including consideration of the feedback that we hear from reporting issuers, that we hear from the audit firms, and, you know, we're all trying to just make sure that we're all promoting that correct balance between a reasonable audit process, but ensuring that there's adequate audit quality. And, you know, I'm confident that this balance can be reached, as you know, it's important. All parties involved want our venture issuers to thrive, but we also don't want Canada to be in the headlines or investors to be hurt by audit failures that some other countries have recently seen.
All right, thanks for that perspective, Brian. Lynn, this question's for you. We heard earlier discussion about the importance of measuring the burden and understanding the benefit when we put in place regulation on the issuer side, but I'd like you to speak to that paradigm as it relates to the small dealers, and how can we address the question of burden and allowing small dealers to continue to flourish and serve a part in the ecosystem.
Right, so we are hearing that there is a shortage of dealers that support the venture market, and that is backed up by the numbers. I'm only going to walk you through one of the numbers. I looked at a list from 2013, so 10 years ago, of dealers that supported the venture market, and 1/2 of those dealers on the list are gone. And although there have been new firms entering the venture market, there are not enough to fully replace the ones that have left. And some of the surviving dealers have shifted their business to wealth management and have stepped away, at least to some extent, from financing the junior markets. So, you know, we've heard that our rules, which now include the client-focused reforms, make it difficult for registered dealers to raise money for early-stage companies. So, you know, we're going to go out and make some inquiries as to how firms are interpreting the new rules, and we will clarify our interpretation where necessary. We're going to look into whether we can help firms, I think, dust off some of the old work we've done on Staff Notice 11701, but also we'll look into whether we can help firms make their suitability analysis and due diligence processes more cost-effective, but without sacrificing investor protection. You know, and finally, for investors that have a genuine interest in early stage investing and the financial capacity and or experience to get involved in that area, is there anything regulators can do to help investors get access to greater investment opportunities? That's something we're going to try to answer. I think there's opportunity. But We also understand that junior market participants are wondering whether exempt market dealers could step in and fill the void created by the exit of small dealers from the public venture markets. And there are some EMDs that are willing to get involved, to try getting involved in the financing of early stage issuers, both public and private. But EMDs face the same due diligence cost challenges as zero dealers. So the economics of financing small companies is not better for EMDs necessarily. And the EMD registration category limits them from getting fully involved in the public market. So we're considering what can be done here without creating uneven playing field issues and also considering risks.
Thanks very much, Lynn. Denise, I've got one for you now. We've heard about the different pieces of capital that's available. You've got public market, you've got private, you've got venture. When we make regulation, we can have impact in potentially driving towards one or the other. How can we find the right balance in terms of how we regulate these spaces?
Okay. I mean, I think in part we have to understand what our market looks like and you know, the changes that are happening. Ryan talked about the Alberta Capital Market Report. When we did our first Alberta Capital Market Report back in 2004, it was a very different market than what we have now. Back then, we identified that we were the second largest, had the second largest number of large senior issuers after Ontario. We had the second largest number of smaller venture issuers after British Columbia. But today, our market looks quite different. We see that we still have those, as Ryan mentioned, we still have those large senior issuers, and in fact, they have gotten even larger. They're not, we call them Alberta reporting issuers, but they are international companies with international operations. They represent a significant aspect of the TSX S&P 60. Many of them are listed on the New York Stock Exchange, and in many cases, they have cross-border executive teams. When we look at the venture space, and so historically the venture market has been a way for companies to raise money. In Alberta, that space has seen significant decline in the last 20 years. We had, in 2012, there were 302 Alberta, I should just back up. We've seen a significant decline, and really it ties into what we've seen in the oil and gas sector and the decline in the junior space in the oil and gas area. So in 2012, when we look at it, we had 302 Alberta reporting issuers engaged in oil and gas activities. Today, there's maybe 115. Then if we look at like those, the very junior ones, we went from around 210 in 2014 to about 73 today. Some of that reflects changes in the oil and gas industry. Some of it reflects the fact that we've made it so much easier to raise money privately. That companies can stay private longer. Some of it reflects the changes in the maturing of the private equity and the venture capital space in Alberta. So there's alternatives to going public. Lynn spoke to the decline in the number of smaller dealers. 20 years ago, a promising young company might get pitched by a dealer on the benefits of going public. And if they did, there was a whole ecosystem of lawyers, accountants, valuators, and others to support it. Today, they might be just as likely to be looking at venture capital or angel investors or private equity for their financing. So I think understanding the market that we regulate helps us to figure out what the balance is and where we devote our resources. For those larger issuers, I think we continue to have to look at what's happening in the US. The MJDS, the multi-jurisdictional disclosure system, is so important to Canadian issuers accessing US markets. So making sure we're aligned there, and also, as mentioned on an earlier panel today, and competitive. When we look at the growth space, as Deborah Yedlin was speaking about, we're looking at devoting more resources to the private markets. making sure we're understanding how they're raising money in those emerging industries in the tech sector. You know, to some extent, as long as investor protection concerns are addressed, we can be agnostic about what's the most efficient way to raise money, whether it's public or private. But we need to understand what's happening, and I think, you know, we also need to think about it from the investor perspective. We continue to see the growth of ETFs. You know, more and more investors investing both in the public and private space, as Ryan mentioned, indirectly into companies. So we're seeing, you know, maybe less of that direct retail investment into companies and more of the indirect investment through funds and other collective investment vehicles. So again, just for us, I think it means allocation of resources, focusing, you know, more attention on the private markets and more attention on sort of what's happening in that fund space, and just generally understanding it so we can look at, you know, how do we support capital formation in the province. Thanks very much, Denise. So my next question, which is going to focus a little bit more on the enforcement piece, you know, our capital markets must be and must seem to be a capital market with integrity in order to enhance the confidence of all participants in its fairness and efficiency. And this means that it's important to design and implement mechanisms for dealing with bad actors, particularly given changes in methods of market participation and increased use of social media. So this question's for both Ryan and Cynthia. How can the proliferation of technology fuel securities misconduct, and conversely, how can technology mitigate the risks of such misconduct?
So I'll start on that one. You sometimes hear it said that when it comes to securities fraud or financial market misconduct, there's nothing new under the sun. And while that is true to an extent, you see bad actors using old methods to continue to enact fraud on investors. That is true. We are, however, seeing new forms of technology deployed into capital markets contexts in new ways. And so I grabbed a few headlines. I'm not going to go through each one, but you can scan it very quickly. You can see it up on the screen. We're seeing things like artificial intelligence-fueled deepfakes facilitating fraud, voice cloning scams, something we call astroturfing, or creating fake sentiment around certain trends on social media. And social media can catalyze investor herds and drive behavior in ways, because of how interconnected we are, particularly how global our markets are, in ways that maybe we haven't quite experienced before. And this is getting faster and more rapid. And so it's something that we're very aware of and actively working to work against.
Thanks, Ryan. I'll pick up from there and say technology has leveled the playing field for who can be a victim. And I think that's a really important message that's actually worth repeating. Technology has leveled the playing field for who can be a victim. Because oftentimes, I still, in conversations with people, encounter people who think, I know better than that, I couldn't be victimized by something. But there actually is a means, whether it's a scam or some other opportunity, as Ryan's indicated, and through these headlines, where you may not even have any awareness that you've been victimized until someone else brings that to your attention. So I really want to get the message across that every person who is in this room today, and every company and agency and other entity that is represented here today, is a potential victim. That's the new reality that we're facing, and this reality is hurting. It's hurting legitimate businesses and professionals whose websites and identities and voices are being used by others for their own nefarious purposes. It's hurting Canadians across this country. Thousands and thousands of Canadians are being victimized by these investment scams that are going on right now, and that is causing a reported loss of hundreds of millions of dollars, and believed in Canada actually to be billions of dollars in the last 2 years, of loss to individual Canadians that is uninsured financial loss. So different, say, than the auto theft that we see going on in the country where most people who are victimized by that would have insurance that would cover it. These are all uninsured financial losses to people across this country and in this province. And it's as a result also causing a loss of trust by people in investing. Who do you trust? How do you know who to go to? That voice on the phone that you may think is your broker, who you've been dealing with for the last 10 years may in fact not be. That website that you go to that you may think is an issuer's website that you've been going to for years may in fact have been copied and being used for nefarious purposes. It's become that sophisticated and it's accelerating at an incredibly rapid pace. And that I haven't even begun to touch on how technology is used in other ways in the commission of other types of securities misconduct. So for example, with messaging between individuals where now, it's on messages that disappear instantly and there is no traceable existence of a message ever having occurred, which obviously makes investigations where it's important to know what was said in communication information that was exchanged, makes those more complex now. So it's not all bad on the technology front. We are finding ways and across the ASC to use technology to our advantage as well as a regulator. And so we are using artificial intelligence increasingly in finding ways that A, to detect what's happening out there and then B, in our ability to analyze what's happening. The CSA has developed what's called a market analytics platform that detects suspicious trading activity and assists us along with our data scientists in Ryan's division in analyzing trade data to detect potential anomalies and whether insider trading or other nefarious trading activity may have occurred. We now have the capability and software to do crypto investigations, cryptocurrency related investigations. We also have new software this year that we've brought in that gives us more advanced artificial intelligence and machine learning capabilities across all of our investigations that we're doing so that we're able to analyze the large volumes of data that we receive in our cases much more rapidly and with the benefit of technology aiding us in the analysis. The ASC is also using technology in a way it's primarily through social media, but to get the word out in a timely fashion to the masses about what the misconduct trends are that we're seeing and what sort of steps you and others can take to protect yourself. So I'll leave it there for now.
That's great. Thanks very much, Cynthia. I'm just mindful of time because there are a couple of questions I do want to get to at the end as well, but I don't want to miss this opportunity to ask Cynthia, yourself, and Katrina in particular about social media proliferation. We have seen increasing concerning promotional activity utilizing social media to expand the reach. What are the possible ways to address that, and what are the considerations that we have to take into account in doing that?
Sure. If it's okay, I'll speak first. I'll give just some quick examples of the different ways in which we're seeing promotional activity manifest on social media, and then I'll turn it over to Katrina and talk about what our thoughts are and how we approach this. So quick examples on what we're seeing manifest with this. We see in various types of chat rooms where there are pump and dump schemes that are being touted heavily. And we see financial influencers who are being hired or receiving compensation through things such as clickbait in promoting stocks. So they may or may not have a direct tie to the issuer or any direct form of compensation through the stock itself, but rather being compensated just by the number of people who are following them online. We see third-party promoters who are going out and are touting stocks through social media where they're not disclosing compensation that they may have received from the issuer, or they may have been compensated by an unknown third party, unbeknownst to us, and whether or not that party is related or has any connection to the issuer or to a security holder of the issuer. So we're seeing this manifest not only here in Alberta, across Canada, you see it in the US in the headlines as well. We're seeing a lot of different types of promotional activity that is quite concerning and that we have our eyes on.
Yeah, so I'll jump off that, Cynthia. And in terms of possible ways to address it, I mean, the simple answer is we need, as my division looks at is what is the authority we currently have under our act, and we assess whether we can address some of the problematic promotional activity or enhanced by social media in order to adequately protect investors, or under the current framework, or not. I mean, clearly the world has changed in terms of how people communicate information, consume information, communicate with each other, engage in commercial transactions, including financial transactions. I think social media has given everyone instantaneous access to a never-ending audience, a global audience of people that are limited only in their willingness to listen. So when you think of a influencer or a finfluencer, as the term has emerged, but the very term used there is the intent is to inform, influence, and lean on the public and shape their views. So when this spills into influencing investment decisions, or decisions in financial services, we want to make sure that it's done responsibly and transparently. So if someone is promoting a company and getting paid by the company, our laws currently address this inherent conflict of interest, and the public should be aware of it in making their investment decisions. We use the term investor relations activity in our act, and we require people to disclose the fact that they're engaging in this activity in relation to a particular company. And our laws currently obviously also prohibit false or misleading statements or omissions, which is another statutory mechanism that we have to put guardrails around sort of over-ambitious promotional activity. But there's definitely some gaps in our current framework. Currently, we don't require disclosure of the amount that a person is being compensated, only the fact that they're being compensated, or if they're receiving compensation for endorsing a company in a different form, they receive compensation shares in the company, or if they have a long or short position in the stock, or perhaps they're receiving a benefit in another way from a third party, as Cynthia mentioned, in the form of advertising revenue, payment for clicks. These are all examples of things that we're seeing and considering whether they should be made more transparent, and if our current regulatory rule framework enables us to provide this, to require this type of transparency. The other thing is, we see if someone is launching a tirade against an issuer, a social media campaign in furtherance of a political or social agenda, and there are misstatements and omissions being made. Under our current framework, those statements would have to be material to be offside, and providing materiality can be different. Is this something we should be addressing, or from a rulemaking standpoint, or is that going too far? British Columbia has taken steps to plug some of these holes and address some of these gaps in their legislative framework, and the BC Securities Commission has come out with a proposed rule requiring enhanced disclosure of parties engaging in promotional activity in relation to a stock or issuer, and receiving compensation for that. So BC has already put that proposal out on the table. Here in Alberta, I would say we are continuing to look at this topic and discuss what makes the most sense for us, looking at our market, speaking to enforcement, corporate finance staff. ARCM is looking at data, and we're considering approaches taken in other jurisdictions. We're assessing where we think the line needs to be drawn, being mindful of finding the right balance, protecting investors, but not over-regulating or potentially bumping up against constitutional rights to freedom of expression and association, obviously. In my mind, it's getting clear on what the concerning behavior that we see is, and what's right for us as securities regulators to address the problem in a thoughtful, surgical way to make sure we hit the right mark.
All right, that's great. I appreciate those views from both of you. So I'm going to take you to our last question before we get to a couple of questions from the audience. And I'm going to ask you to all be tight on this. Ryan, you get to sit this one out because I want you to save your energy for the next panel.
Thank you.
So I'm going to ask Lynn, Brian, Katrina, Cynthia, and Denise to answer this one. I want to ask you about the role of securities regulators today, and in particular, given the theme for today's event, what is intelligent regulation and what does it require of the ASC?
Right, so intelligent regulation. It needs to work for all market participants. And so from a market reg perspective, I have this voice in my head or somewhere saying, you know, currently the number one complaint that investors have, conveyed to OPSI, is that the investments firms put them into are not suitable for them. And so any adjustments that make firms' regulatory requirements proportional, and I think that's a big part of intelligent regulation, must still and at all times meet the fundamental objectives of regulation, which includes investor protection. And so that seems like a disclaimer at the front, but that's true. And so that said, for those that try to comply, we need to consider how we as regulators can help with reducing the cost of compliance. We can do that in a number of ways. And first, we have to be and stay informed about the issues faced by investors and challenges faced by our regulated community and the general state of the market. So the key for us is to stay in touch with industry and investors. And then we need to be clear in our expectations and be fair and consistent in applying the rules, both here and across the country. We need to be accessible to business as they plan their business. But, you know, we're not advisors and we're not legal counsel for industry, and we must avoid conflict. So there are limits to that, but we want to be accessible. We can do things like develop standard forms and resource materials for industry to save time in achieving compliance, and I believe there's more that can be done here. And identifying the risks and applying the rules proportionately is also key, and we've done this and we'll continue to do this, and if you'll bear with me, I have a really great example that I always think about. And it's my predecessors at the ASC have done this. So an example of successful proportionate regulation is in the history of the ICE NGX exchange and clearing agency, I think. NGX started business in the early 1990s, and we exempted them from recognition as an exchange and clearing agency with tailored conditions until 2008, so for a whole decade and a bit. Requirements were increased as business expanded, and that's calibrated regulation. And having said that, a material consideration that NGX's market participants were not retail. They were businesses that met high financial thresholds and sophistication in the industry. But today, ICE NGX is an example of a locally built, successful enterprise that benefited from intelligent regulation.
That was so good. That's tough to follow. Okay, I'm going to keep mine pretty short and sweet. So, you know, it's really listening and really understanding the views of our impacted stakeholders, and then, you know, weighing those views and coming to the best decision possible. That might sound really obvious, but it's actually really hard to do. You know, for example, on one of the issues I'm currently working on, you know, I'm hearing from two groups that I very much respect and trust and have known for a long time, and they're expressing very, very opposite views. So, you know, the ASC's focus on being an intelligent, best-in-class regulator isn't always an easy one, but it's certainly an important one.
I think I have three things to add to that, and I agree with everything Lynn and Brian have said. For me, the role of the securities regulators and what intelligent regulation requires, I think we need to meet our market where it's at, be willing to respond nimbly to technological development and new business models that challenge traditional operational understandings in the market and traditional regulatory structures. I think This is challenging for us in many cases, but I think there's room to improve, but I think it's really important. Secondly, I think intelligent regulation requires strong collaboration and alignment with our government in exercising our delegated authority to administer Alberta securities laws. Some of the most topical matters we're dealing with raise challenging and potentially divisive issues, and for me, the open line of communication with our ministry and mutual understanding is crucial. And the last thing, I would say harmonized results. We've heard this morning from the chairs. Harmonized results that make sense across the country. Even when it's challenging, being committed to the CSA process of working towards harmonized requirements, because ultimately that's what's best for the market. Market participants need to operate across the country and have operational efficiencies and consistency across the jurisdictions under as unified a regulatory framework as possible. And I think we need to support that.
I'll just add one point very briefly. In addition to what my colleagues have said, I think intelligent regulation in the securities world right now from an enforcement lens really requires us to have our eye on the horizon, to anticipate the potential harms that are out there, and in our policy development, to be contemplating how we can best prevent or mitigate those harms that may materialize. So whether that's through a policy or a legislative or rulemaking provision, whether it's through education or other means, we really need to be thinking ahead of what's happening on the technology front and how to address that.
Okay. What's left? I had the benefit of having better prepared colleagues than myself, so I got to see all their comments, and I was like, I don't know what else to say. They have it all covered. I echo their comments. I guess one thing I thought is, one thing that helps to be an intelligent regulator is to be a problem solver, a solution finder, to be creative. I've done some mentoring for young lawyers, and I will often tell them, if you're a lawyer who can identify all the rules for your client and tell them what they can't do, you're a good lawyer. But if you really want to be a valuable lawyer, you need to understand their business and what they're actually trying to achieve. And then sometimes you can find, even though they can't follow the path that they were hoping to follow, you can get them to the place where they want to be with a creative solution. And I think that's probably the same as a securities regulator. If we can really understand our own rules, understand the policy rationale behind them, why they exist, and understand what those that we regulate are trying to achieve, we can not always, sometimes we just have to follow the rules. They are what they are. But sometimes you can find creative solutions to problems that still address the investor protection concerns, but in a different and alternative manner.
Wise words, Denise. Thanks. Glad you went last. So we've got a few questions. There's one I want to make sure we get to, and not just because Stan's our boss, but because it's also a fair question that was asked earlier this morning. It was on enforcement statistics, and Cynthia, I wonder if you might be able to address the question that came up this morning.
Sure, happy to. So a question came in earlier today about our collections and what do our collections look like. So I want to situate that in context for everybody. When we take formal enforcement action against a person or a company, we do so through one of two different types of streams. One is regulatory, where we take matters before administrative panels, and the other is in court, what we call quasi-criminal or criminal charges that are laid against someone, and we prosecute them in court. So we, at the ASC, we have both avenues available to us, and it's an internal assessment as to which path any individual matter, any case may go down as to what's most appropriate. where we see some of the greatest needs for specific deterrence and where in fact the evidence suggests that punishment may be needed in order for someone to really learn the lesson, we're more likely to lean towards the criminal or quasi-criminal side where people are disciplined or sanctioned, sentenced in court. So when we're talking about our collections numbers, it doesn't include our court cases, but I think it's really important that we have an understanding, because we've worked really hard at the ASC, certainly over the last 15 years, and intensified that over the last 7 or so years, to amplify the number of cases and matters that we're bringing with serious securities misconduct into court and seeking significant sentences in that regard. So earlier this year, I think it's worth mentioning that we had an individual who was convicted in court on securities fraud, Jordan McBean. The name may be known to some. He was sentenced to 7 years in jail. That's the lengthiest sentence any Securities Commission has ever obtained on a matter that they brought before the courts for securities misconduct. So it's one indication. We have another person who's scheduled to be sentenced later in October and another one in November. So we have certainly ramped up our efforts on the criminal sanctioning to deal with some of the real egregious misconduct that we have seen over the years. On the administrative side of the house, so when we bring a matter case before our panels have the ability to impose administrative penalties at the end of a hearing if they find that someone has been liable for engaging in any form of securities misconduct. The maximum penalty set out by statute is $1 million per breach that they've engaged in. And the person or the company can also be ordered to disgorge, to cough up any amounts that they obtained as a result of their wrongdoing. So we see panel orders that sometimes can be quite high, depending on whether the person has profited from their misconduct or not. But typically, when we're looking at the administrative penalties, a panel will impose a penalty in relation to, in proportion to, the seriousness of the misconduct and what is needed to deter that person and to protect investors and market integrity. The panel does not do a dive into that person's pocketbook or bank account and say, do they actually have the money? And in some cases, the administrative penalty imposed is more than the person ever actually took in or had during the engagement in the misconduct. So I think that's really important to understand, is that it's not that the panel imposes penalties and people just have this money sitting in bank accounts. In fact, very often, by the time we find out about misconduct, if there was money to be had, it's often gone. Where those opportunities do exist, where we find out early enough, we have the ability to go forward with something called a freeze order, where staff can ask the executive director, provide the grounds upon which we say we believe there may be some misconduct happening and there are some assets. We want those assets to be frozen until we can complete our investigation, and if the matter proceeds to a panel, the panel can adjudicate upon it. What happens sometimes with those freeze orders, and just within the last year or two, on behalf of another provincial securities regulator in Canada, we froze a bank account here in Calgary that had about $16 million in it. Froze it early on in the investigation. And as part of the investigation, we're actually able to negotiate that the monies in that frozen account would be returned to the investors. So before the investigation was concluded, before the investors were given an option, if you would like your money back, you can, and over 99% of them said, yes, please, send me my money back. So those are the sorts of stories that when we fixate just on numbers of collections amounts, those are the types of things that we do to protect the market integrity, to protect investors, to hold people accountable for their misconduct, to send messages of both specific and general deterrence. And I believe the question earlier today asked about how do our collections stats compare with other jurisdictions. And I will say, one of the things I've come to really understand in this space is when you try to compare even between provinces, but certainly as you go, you try to compare what's happening in Canada to say the SEC, it really matters who is the target group that you're taking action against. Because if you are, I'm going to use zero, if you're a self-regulatory organization and the parties that you take proceeding against are regulated participants who actually want to continue in the business, they're going to need to pay their penalties to do so. It's a term of engagement, and so you'll see collection rates there much, much higher. If if you're a regulator that has within your ambit financial institutions or other very large, some of the TSX listed entities where they have large financial capabilities, you're going to see much higher collections rates. If you're going after individuals, small groups of people, people that may actually not even be formally in the capital market, but certainly are impacting it, you're going to see your rates much, much lower. So when we look at the SEC's collection rate, the SEC has a very high collection rate. Why? Because they actually recover tens, hundreds of millions of dollars against a very small fraction. And then more of the entities that are more commonplace in the types of parties we're bringing to proceedings, their collections rates are very similar to ours. So I don't have the exact numbers here today. We will follow up with whoever submitted the question when I get back to the office and can pull some data and share those. But I think it's really important to understand that context, that we work really hard to disrupt, to preserve assets where they exist, to hold people accountable, whether that's through orders issued by the panel, which also include bans, not just monetary sanctions, and we take proceedings in court where we think that's warranted and look for jail time.
Perfect. We used up the exact amount
Sorry,
of time we
used
had
up all
for
the
questions.
time.
There are other questions, but I'm mindful that we want to make sure that we adhere to the promise I made at the beginning of the day, which was we were going to run a tight ship and stick to the schedule. We do have names, I believe, for the folks who sent us questions, and if their emails attached or email addresses attached to that, we will get back to you offline. Thank you for your questions. Thanks to all of you for your in-depth responses, taking the time to put together meaningful and substantive commentary that I hope our audience found insightful today. We'll give them a better insight into what the ASC is thinking and how we go about doing our job on a daily basis. And thanks to all of you for your attention.